Hi, this is Casey O'Connell with Halloran Sage's Business Transactions Group, and I'm here with Ann Catino from our environmental group to talk about the Transfer Act. As we've mentioned in one of our previous conversations that you can view on our website, the Transfer Act is a law of wide applicability for environmental matters concerning the transfer of any business or piece of real estate. And as we previously discussed, there's a sunset that is currently in effect for the Transfer Act, where legislation has been passed regarding a potential replacement for the Transfer Act. But in the meantime, until that replacement is fully enacted, the current Transfer Act remains on the books and is a matter that business owners who are purchasing a business, selling a business, purchasing real estate, selling real estate, or even leasing real estate will need to keep in mind. So, Ann, if you can just tell us a little bit about the Transfer Act, when it comes into play, who is typically responsible for complying with the requirements of the Transfer Act?
Under the Transfer Act, the burden is on the seller of real estate. The seller is strictly liable, or the seller of the business. The Transfer Act applies either to the sale of real estate or to the sale of a business. And the seller is strictly liable for the compliance with the Transfer Act. They're responsible to DEEP, they're responsible to the buyer. So the burden falls in the first instance on the seller to make sure that the property or the business sale will be done compliant with the Transfer Act. Typically, buyers as well are very interested to know whether or not a site qualifies as an establishment under the Transfer Act as well, because they don't want to have the liability that may follow them as a new owner of either the business or the real estate. So buyers are incentivized as well to evaluate whether or not the Transfer Act applies. Typically, it comes up in the context of due diligence, either the representations and warranties, Casey, which you can talk about in a purchase and sale agreement. It also comes up in a phase one environmental site assessment. Many environmental phase one site assessments are done in accordance with the ASTM standards. But as part of those standards, you look at the generation of hazardous waste and whether or not hazardous waste was generated and how much was generated, as well as the property history. There are interviews done in phase ones with the current property owner. You look at the old Sanborn maps. You do historic record searches at DEP and at the local land use agencies. You create a lot of information about a property that's important for a buyer to understand. And banks, lenders, also want to see the phase ones. The phase ones provide protection from liability under the innocent landowner defense, under federal law and state law, but they also provide a framework for determining whether or not the property falls in the establishment category.
So what would happen if a transaction occurs and the Transfer Act should have been complied with but is not? Does that mean the seller would be liable for any penalties or remedial actions that would need to be taken, or does that fall on the buyer, or is it a combination of both?
It's ultimately a combination of both. Under the Transfer Act, the commissioner can go after either the buyer or the seller. However, if there's a failure to file, comply, the buyer also has a cause of action under the Transfer Act law that allows him to or her to go after the seller for failure to comply. And the seller is strictly liable, is fully responsible to the buyer for any failure to comply with the Transfer Act.
So it sounds like it's really at the end of the day, it's more on the seller, but it actually is a mutual responsibility. I mean, because it seems like if a buyer purchases a Transfer Act property and then the buyer doesn't do anything, but then the buyer becomes a seller in the next transaction, then it sounds like the buyer would be on the hook. So unless you're planning on holding a property indefinitely, as a buyer, you have a very vested interest in ensuring Transfer Act compliance as well.
That's correct. And I guess the next question becomes, what does it mean? That's where you get involved in the negotiation between the buyer and the seller, depending upon what side we're on. It has to be negotiated as to who's going to take responsibility. Once it's determined it's an establishment, for investigating and remediating the property.
Right.
And that will be the subject of our next video.
That's right. That's right. I'm looking forward to it. So, thank you very much, Anne. And we will continue this in our next video in this series. But until then, if anybody watching has any questions or any Transfer Act needs, please don't hesitate to reach out to a Halloran Sage attorney, and we will be sure to see if we can help you and steer you in the right direction.
Thank you.
Thanks.